All right, guys, we're going to let Ryan Zinn get started on his thing so he can finish that up, and then we'll have some time afterwards to finish up eating and talking and doing whatever else we want to do before the holiday. Just a couple of announcements. I do have our email listserv addresses here. There's not a lot of people here to update it, but I'm going to pass it around. I have had some bounce backs, as well as if you want to change your email address from what's on our listserv to a different address, just scratch it out and put it on there. Or if you see somebody that that's not on here that you think might want to be on our listserv, you can add them on there and I'll put them on our list. Just a couple other announcements. Judge Delano will not be here in the afternoon, but she did ask me to say happy holidays to everybody, and she's sorry she could not be at our meeting today, but she wants to get back to Tampa before the afternoon hearing so she can do it via video. I also emailed Judge Delano's chambers regarding possibly modifying our mortgage modification procedures under the order in Chapter 13. We reviewed Southern District's mechanisms, and they use an e-portal system so that then they require the lenders to get the documents via an e-portal that is the documents are all uploaded to, so there's no question whether or not the documents were provided before mediation, etc. I was told that Judge Delano was attending a conference that Judge Jenneman is setting up in February sometime, where they're looking to unify the district with mortgage modification procedures. One of the topics is going to be adding an e-portal element to our system, so hopefully something like that can be done. Anyone that wants to go give their 2 cents on that is going to be welcome to go once they have it in February. I have the dates in my office, but if anyone from our organization wants to go, I can email those out to you.
We should probably also get some kind of uniformity on how the mediators are paid. I know in Tampa they do it through the Chapter 13 trustee, and they do the same in Orlando, and down here we're kind of doing it flying by the seat of our pants.
Yeah, I agree. That could be a topic that we bring up that could be addressed in our procedures if they do a uniform order, as well as Southern District. If it's a no-look fee that we get, there's no need for an application, and the same thing in the Southern District. If they have a no-look fee, it's a little higher than ours, and we're always wanting more, knocking on the door trying to get more. But even if we don't have to go through the fee application procedure, and if it's just a no-look, then it should just be approved. Other than that, again, I can send out the dates for that conference, and anyone that wants to attend, or if someone is going to attend, let us know, and we can email our thoughts to them, and they can raise them on behalf of your association. I don't know if I'm going to be able to go yet, but I'll know closer to that date. Next meetings for next year, again, I'm always looking for topics on what we can do to just have a topic for discussion, get CLE credits. So if you have any ideas, feel free to shoot them over. I had an idea for possibly doing 2 roundtable sessions, one for consumer issues and one for business bankruptcy issues, and have a trustees representative, consumer debtor, and counsel, and trustee creditor representation at the table, and just kind of going over hot topics and back and forth for a couple minutes, and then switch to topics, and maybe that'll fill some time to be an interesting debate. Other than that, today we have Brian Zinn. He's going to give us a little case law update. I have applied for CLE credit. We'll see what the Florida Bar says on that one. I haven't gotten the numbers yet. They're falling behind. I still don't have the numbers from last meeting's CLE, but once they're given, I'll put an email out so you can get your credits for attending. And with that, Brian.
You can get us some ethics hours.
I tried last month. We'll see.
Yeah. I know it's hard.
Last
You
month,
have to teach ethics.
last month being malpractice, I thought that was appropriate. So.
Should be.
Yeah, that does make sense.
Okay, good afternoon, everybody. First, I'd like to wish a happy birthday to Holly McFall.
Hey.
It's her birthday today. I'm also going to be giving some quick case law updates today. I'll try not to keep you too long. The first 2 cases are both from the 11th Circuit, and you've probably already heard of them. But after those 2, the others you may not have heard of. They're from other circuit courts of appeal and other bankruptcy courts. And I figured we could also, we could play You Be the Judge. And you tell me how you think it's going to come out, because they're all pretty interesting cases. And some of them I would have decided a different one. But, okay. The first case is called In re Colburn. It's from the 11th Circuit. Colburn is Colburne, and it involves a Chapter 20. That's where the debtor first files a Chapter 7 and then files a Chapter 13 in an attempt to do some type of cram down or strip off. And the issue here is that the debtor had 2 investment properties, not homesteads. And there was just one mortgage on each investment property, and the mortgages were more than the value of the property. So the debtor wanted to cram down those mortgages to the value of the property. You can't do that with a homestead in Chapter 13. There's a restriction on that under 1322, but there's no restriction on investment properties. The only thing is that if you file a Chapter 7 first and then a 13, you're not going to get a discharge in Chapter 13. And there's been a split among many courts saying you can or can't cram down or strip off things if you're not eligible for a discharge. I believe when Judge Sherman was here, he had decided, I don't remember if it was in this circuit or in the circuit he was in Missouri, that you could strip off things or cram them down, regardless of whether you get a discharge. Well, the 11th Circuit looked at it, and they looked at Section 1325A5. And that section basically says that that a plan can only be approved if, with respect to each allowed secured claim, one of 2 things has to be true. Either the person is going to get a discharge, or the payment of the underlying debt determined under non-bankruptcy law is paid. So they looked at that and they said, well, you're not getting a discharge, so we're going to say that even if you want to attempt to do a cram down, it would not be effective because you still have to pay the first mortgage in full under the plain language of 1325A5. So the 11th Circuit has said that in a Chapter 20, you cannot cram down a mortgage to the value of the property. Now, there was a footnote or a side thing at the end that basically left the door open on second mortgages that are wholly unsecured, and if you can strip them off. And they said that that might bring into play different code sections because it might not be considered a secured claim. They didn't go into the details of it, but it sounds like they might come out differently if it was a strip-off. So you might still be able to do a strip-off of a second mortgage in a Chapter 20 case, but the 11th Circuit left that open. And that was Colburn.
That's pretty much moved under McNeil anyway. Stripping off is allowed in 7. So.
Oh, that's right. Under McNeil, right now, strip-offs are allowed. But we don't know.
Did
As a-
Colburn come out of the Southern District?
I do not know. Sorry, I don't have that.
Because the Southern District used to allow you to do it in a 13, even if you had the 7 discharge.
Right.
We did not
Okay.
here. So I think Colburn came out of the Southern District. That's how it came out.
But if you read that footnote, I think they were, if it was residential property, they probably would have went the other way on it. I think that's what they were.
Yeah, they could have gone the other way if it was a strip-off. Okay, the other case, which is close to home, is Kulikowski with a K, and that was actually decided by Judge Delano, and it involves a non-filing spouse, and the non-filing spouse is the one who made all the money for the household, and the person who filed bankruptcy, the wife, did not have any income whatsoever, and she filed a Chapter 7. And the question is, does that case get dismissed as an abuse of Chapter 7. And the 11th Circuit affirmed Judge Delano. What Judge Delano did is she looked at the totality of the circumstances, which is one of the things you can look at in determining abuse. That's 707B3. The means test is 707B2. So everything that is encompassed in the means test of 707B2, which that also includes current monthly income, all that comes into play under the means test and not under the totality of the circumstances test. So the 11th Circuit looked at it and said, well, you may be correct that the husband, that you don't look at all of the husband's income. That's the non-filing spouse here. You don't look at all of the husband's income if you're looking at the means test. That's why there's a marital deduction or marital adjustment. Because the definition of current monthly income includes only contributions to the household expenses of the debtor. It only includes household expense contributions of the debtor and not anything more than that. So it could be that only part of the husband's income would be considered under the means test, which is 707B2. But the totality of the circumstances test of 707B3 is pretty much a catch-all. It doesn't mention current monthly income or any such definitions. So the 11th Circuit basically said you can look at anything and everything. And it was proper for Judge Delano to look at the totality of everything, including all of the husband's income, and in dismissing the Chapter 7 case. The 11th Circuit, though, pointed out that it might be different under the circumstances of another case. So you'd have to look at it as under a case-by-case basis. In this case, there was a 21-year marriage. They had shared all their finances, and some of the credit cards that were being discharged were used for the non-filing spouse's benefit. So the case may have come out differently if they hadn't mixed everything and it wasn't a long-term marriage. You could possibly say that you don't consider all of the husband's income in that scenario, but they didn't go into that part of it. So that's Kulikowski, and that's the 11th Circuit. Okay, time to play you be the judge. This comes out of the 6th Circuit. It's called Lamp versus Cash. In 2004, Stephanie Lamp obtained a judgment in district court of $25,000 against Kurt Cash. That was in 2004, and she was represented by a law firm. 8 years passed, and then Kurt Cash files bankruptcy. He lists on Schedule F, Stephanie Lamp, care of the law firm. The law firm's address is still there, and everything's fine. And the notice supposedly went to her attorneys, her law firm. But for whatever reason, they did not go into it. Stephanie Lamp never got notice, actual notice of the bankruptcy. She goes to the district court after the discharge is over, after the bankruptcy is over, and the district court says, sorry, your judgment's been discharged. She appeals to the 6th Circuit. You be the judge. What would you do? Yes?
One follow-up question before they get to answer that.
Okay.
Was Mr. Cashier's bankruptcy an asset or no asset case? You know?
They did not say that.
Okay.
They did not say that.
Now
But that didn't come into play in the opinion.
Had the law firm ever withdrawn from the state court case?
They did not say that. They just said that they just said that 8 years had passed, basically.
As far as if it was me, I'd say he got proper service.
But I think they ruled the other way. I think they said that it's not discharged, but as I recall.
She didn't get notice.
She didn't get actual notice, and she's a real person, and it's not care of somebody else.
Okay. So we have a little mixture of opinions here. So we went up to the 6th Circuit. The 6th Circuit says that usually serving someone's attorney is okay, as long as you had a reasonable belief that the attorney still represented that person. The Sixth Circuit said that since 8 years had passed, he should have attempted to look up Stephanie Lamp's address because he should not have reasonably believed that the law firm still represented her after 8 years. So they were silent as to what would happen if he looked it up and he couldn't find her address. What would he do then? But they said, yep, the judgment was not discharged, and they reversed the district court. So,
Could they reopen the case and add her?
did they what?
Could they reopen the case and add her to no asset case?
I don't know if they could do that.
So no, that's the case, you don't need to.
Yeah, well, the Sixth Circuit has different holdings on that issue. That's why I threw out, I came from the Sixth Circuit before.
So I don't know what would happen if he attempted to look it up and couldn't find a residential address, but I guess that could be the same thing as anyone. If you don't have a creditor's address, you can't get rid of it. But, and I remember recently reading a Seventh Circuit case where they came out the opposite way, but 8 years hadn't passed. It was only like a year or two or something like
Well, the
that.
nice part about it in Florida
Yeah,
is the judgment creditor is supposed to put the address for service in the judgment.
oh, that's true.
Therefore, you have a court order telling you where to serve.
That's true.
At least a reasonable one to start.
You got a court order telling you where to serve. They said, you need to serve me here. If they want to change that, they need to file an affidavit to the contrary. So the law says in Florida, that's where you serve them.
Right. Well, I don't know. If 8 years passes, I don't know if the person has an obligation to update their address in the judgment.
If they want to get served, they do.
Serve everybody.
Yeah.
Under the statute.
So that's the story. The
Bob
question,
got a good answer on that.
how about this? If the law firm got the notice, did they commit malpractice? And they didn't send it to Stephanie Lamp, their client. after
I got
8
another
years.
question. If they got the notice, why didn't they just file a proof of claim and be done? She's
They didn't go into
Client
that.
File a claim for it.
she's,
I get that all the time from these creditors, when I contact them, well, we don't wanna get in the middle, we're not gonna, even in cases where they are owed money.
Although actually, by the law firm not forwarding it, it actually benefited her.
Yeah.
Because
Yeah.
otherwise it would have been discharged.
right.
So, okay. Next case, Fifth Circuit, In re Croft. Okay. Before the bankruptcy,
I got a better, you know what you could do? Could you file it by publication?
That would be a motion in the bankruptcy court,
Yeah.
yeah,
required in order.
possibly by publication.
Then you
Okay.
have to get an affidavit with all the things you did to find her, maybe.
All right, before the bankruptcy, the debtor, Mr. Croft, files a lawsuit against two companies. Just call them the defendants. And Mr. Croft doesn't do so well in that lawsuit. He loses the lawsuit. Not only that, the court sanctions him as well as says you have to pay attorney's fees to, and they're significant, to the two defendants. Mr. Croft appeals that decision. Before the appeal is heard, Mr. Croft files Chapter 7. Mr. Croft files a motion to lift the automatic stay so that he can proceed with the appeal. And he's just appealing his loss and the sanctions against him. The defendants step in on the motion to lift the stay and say, just a minute, these are appellate rights and the trustee should have a right to sell them, the property of the estate. And we want to buy them, by the way.
We get that a lot.
The bankruptcy court grants the motion to lift the automatic stay, says these are purely defensive rights. It's not a chosen action or a cause of action. The district court reverses the bankruptcy court, saying basically it's any cause of action becomes property of the estate. It doesn't matter. It doesn't matter that it's just that the underlying judgment is worth nothing because it's a loss. Mr. Croft appeals to the Fifth Circuit. What did the Fifth Circuit say?
I agree with the bankruptcy judge.
I agree with the district court, obviously.
Okay, mixture of opinions again. Most people are saying bankruptcy court.
No, I don't see how it's not property disturbance.
It's not a chosen action.
If he affirmatively is trying to bring an action against someone else, he's trying to appeal it himself. He's not, it's irrelevant that he's got sanctions against him because that part of it would be discharged in the bankruptcy, but by affirmatively going out,
Not necessarily.
well, by affirmatively trying to set aside the original judgment and going forward, I think at that point it became an asset.
Well, most people are agreeing with the bankruptcy court, and there's a reason why I reported this decision, because Diane is right. The Fifth Circuit affirms the district court and says, even though the judgment underlying the appeal has no value to the estate, the appeal itself has value because it can reduce the debtor's liabilities and therefore increases the value of the estate. They said that even though only the defendants will bid on it, and in order to extinguish the appeal, that doesn't matter. The trustee has the duty to maximize the value of the estate. And so just like selling a home that's underwater for $3,000, you can always find a buyer for anything. So it turns out that it was property of the estate. The trustee could sell it. Okay, next, In re Taylor, the 10th Circuit. This is a divorce situation. There's a divorce in Virginia. The husband is ordered to pay the wife $2,500 a month alimony as part of the divorce. The husband pays the $2,500 a month for quite a while. Then he realizes, hey, my ex-wife has been cohabitating with someone else. So he goes back into divorce court and says, I want the money that I've been paying all along for, because I wasn't supposed to pay it once she started cohabitating with someone under Virginia law. The divorce court agrees and says, you know what, we're going to give you a retroactive judgment against the ex-wife for $50,000 approximately. The wife files Chapter 7. The husband brings an adversary proceeding saying this is non-dischargeable under either 523A5, a domestic support obligation, or 523A15, not a domestic support obligation, but still coming out of the divorce judgment. It goes all the way up to the 10th Circuit. What does the 10th Circuit say?
What did the bankruptcy court rule?
I'm not going to tell you.
That's a better way to do it.
Not DSO.
I say not
Non-DSO. Maybe 815, but not 815.
Not 8.5, you're saying, maybe 8.15.
Should you want
Is the
a,
money judgment refund?
should you want an A2?
Money judgment.
Yeah, it's not alimony, it's not a refund.
It's
Dischargeable.
Okay. The 10th Circuit looked at 523A5 first and said it is not a domestic support obligation because although it may be in the nature of alimony maintenance or support, it's not in the nature of alimony maintenance or support owed to the husband. It's only as to the wife. So 523A5 doesn't fly, but because it's not a domestic support obligation, they now look at A15, and A15 includes language at the end that says it's incurred by the wife in the course of an order of a court of record. And that's general enough to encompass this, and therefore it's non-dischargeable in Chapter 7 under A15. In a Chapter 13, it wouldn't be dischargeable.
Virtual 13.
Right. I mean, it would be dischargeable, sorry.
Keeping I come from a completely different place and not knowing anything you guys are talking about.
Sorry.
Why
Do we?
isn't- Why isn't this criminal? Wasn't she stealing that money?
I think what she's saying is fraud is still dischargeable under fraud. fraudulent
Under
circumstances.
fraud, there's a very high standard to prove fraud, and he just decided to file it under the domestic support obligation.
But if he was sending her money she wasn't supposed to keep because she was living with somebody, and she was doing that knowingly, right?
Yes,
No, she was living with somebody that didn't know it.
No, but she knew she wasn't supposed to keep the money after she started living with somebody.
right. But not everything like that is criminal. So, not everything like that is criminal. So,
Yeah.
I'm not a criminal attorney.
They're likely just to say that it's a civil matter, go away. They don't, the law enforcement isn't gonna get bothered.
I don't know, it's Virginia. It's a whole different world.
Yeah.
Yeah, you never know.
Okay,
There you go with the redneck jokes again.
next we go back,
Virginia's redneck?
we go back to the Sixth Circuit for the case of Inree Winters. This has to do with the IRS. The debtor, in this case, filed a tax return for 2004 in September of '05. Okay? 4 years later, in December of '09, the IRS issues a notice of deficiency on the 2004 tax return, saying that the debtor severely underreported his income and he owes an additional $143,000 in taxes.
Severe.
In April 2011, the debtor files Chapter 7. Okay, so we've got an '04 tax return filed in '05, the notice of deficiency was in '09, and the bankruptcy was in 2011. There is, as everyone probably knows, income taxes generally are not dischargeable if it was filed within 3 years of the bankruptcy, just generally. However, I never knew this, but other people here might. There's 26 USC section 6501, which says that 3-year period can be extended to 6 years if the notice of deficiency that's sent out by the IRS shows that gross income was underreported by more than 25%. So, and that's what the case was here. However, this case went up to the Sixth Circuit. Not sure if you can figure out why and what the Sixth Circuit said. You be the judge. Is it dischargeable or not?
Chapter 7?
Chapter 7. And a little hint is that the Sixth Circuit said that none of these parties considered a particular issue. And so they ended up remanding it back to the bankruptcy court with instructions. But what did the Sixth Circuit say?
Discharge.
When was the first return filed?
The '04 return is filed in '05.
The
The
04
notice
was
of
filed in
It's
September
timely.
of '05?
September of '05.
So it's
The notice of deficiency was 4 years later in '09.
Well, that may be what you want to consider, is whether that was
And
charged.
when did he file his
Before the
Chapter
notice of
7?
deficiency.
What?
When did he file his Chapter 7?
6 years.
2011,
If it's
2 years after the notice of
3
deficiency.
years. 6 years after the original filing.
Just shy of 6 years.
Yes. 5.5 years after the initial file.
It would have been dischargeable if you filed within the time period before the notice of deficient filing. That's what I think that means.
Say that again?
If the debtor would have filed bankruptcy in the time period before the notice of deficient filing from the IRS, that debt would have been subject to discharge.
That's possibly correct, but that's not exactly what they focus on.
Okay.
Okay, the answer is that the statute of limitations period for filing the notice of deficiency could have run because 3 years had passed from September '05, the filing of the tax return, and December of '09, the notice of deficiency. So perhaps, and they're actually saying it would have expired, but the bankruptcy court didn't make any factual findings about it, But apparently, the Sixth Circuit is saying that you can extend it from 3 years to 6 years if 3 years already runs before the notice of deficiency is issued.
Like-
Sort of what Greg was
Kind
saying.
of like a motion to extend time, you'd have to almost
Did
like.
I misunderstand what you said about the tax code, though? It says if the notice of deficiency is filed within 6 years of...
No, it just says that the 3-year thing is extended to 6 years
If it happens.
if
The real
the gross
question from
income's
the
more
Sixth
than
Circuit
25.
is the 3-year look-back period under Title 11 a statute of limitations?
In other words, you have to actually
Right.
file a motion to extend time that you're still looking at it and we haven't made the
Should-
determination.
What is the IRS's obligation with regards to giving your client a notice of deficiency? Do you have to give your notice of deficiency within 3 years of filing of the return that creates the deficiency?
That seems to be what the Sixth Circuit
That's what
Sounds
the
like
Sixth Circuit
what-
was
That
battling.
sounds like they're saying.
Now, isn't that a legal decision that the Sixth Circuit could answer without remand?
They didn't have-
They're saying that they don't have, they didn't have enough factual
Well,
findings
they may
in
not
front
know
of them.
whether or not there was a notice that ever went out
Prior.
from the IRS to the debtor, saying, you know, within the 3 years, saying, we're still looking at this, thereby
These
attempting
issues weren't
I don't
to.
raised in
understand, guys.
bankruptcy court level,
Bankruptcy's very
and
simple.
they need the IRS and the debtor's attorney, debtor counsel, to flesh that.
Yeah, they just need to
out
verify if it ever got properly
At an
extended.
evidentiary style hearing rather than a appellate hearing.
So they did rule, though, it was a statute of limitations.
Yeah.
Essentially, yes.
Yep. Okay. Next case is Inree Knowles with a KN. This is out in Kansas, bankruptcy court, and it involves student loans. Debtor files Chapter 13. He's proposing to pay $980 a month over 5 years because he's an above median debtor. I'm sorry, it's a couple. They're above median debtors. Under the means test, B22C, the debtors show negative income. You're not subtracting student loan payments as part of the means test or anything. They did not go into details about it. They just said they have negative income. And on Schedule J, they put a $500 a month loan payment, student loan payment, as an expense, because that's their regular contractual payment. The trustee objects for many reasons, basically saying, you know, you can't pay student loans, you're discriminating unfairly by paying them directly, plus they're going to get a share of whatever you're paying. It's very funny, the attorney for the debtor, who I guess didn't do much preparation, puts in his response to the trustee, "Come now, debtors, and object to the motion to dismiss and show that the trustee is dead wrong in the position he has taken, and debtors will soon show same." And there's actually a footnote on that. And the court
Sounds like Kevin Gleason.
and the court basically says, "This response is wholly unacceptable. It does not provide the trustee or me with a single factual or legal basis for the debtor's position." And they go on saying, "I'm going to refer you to the Board of Discipline of Attorneys if you do it again."
Okay, they don't like the lawyer. What they say about the debtor?
So the question is this unfair discrimination? And the court was mostly focusing on B22C and that there was negative projected disposable income. So what's the answer? What did you be the judge? I know what Mike Cecil would say.
Not,
The
not
question is, can you have a
confirmed.
separate unsecured class because they're a non-dischargeable long-term debt?
The court specifically said no. One thing has nothing to do with the other, about the fact that it's not dischargeable has nothing to do with this decision.
I think you can do it.
Different circuits have different rules. I don't have the faintest idea what this one did.
Okay, well, this judge out in Kansas said that the $500 a month student loan is being paid from the debtor's discretionary income, not projected disposable income, and that's perfectly fine. As long as you're contributing, you're not unfairly discriminating in terms of who gets what from projected disposable income. Now, I don't know if I minus J is considered projected disposable income. I guess this court doesn't think it is. I don't know if that's been decided in our circuit. I don't know if anybody knows that. But basically they're saying that that's okay to pay the student loan directly. And it's only because there was negative income shown on the means test. So actually the debtor's attorney was right. The trustee was dead wrong. The last case is In re Razian, R-A-Z-I-Y-A-N. This is out in California. The wife, before bankruptcy, defaulted on her car loan. And instead of giving the car back to the car loan company, she gave the car to her husband, who she was separated from, and they were in the process of a divorce. He was a car dealer, and she thought that he would just take care of it. At least that's what she told the bankruptcy court. The lender eventually recovered the car, but they found out that they couldn't sell it because apparently their lien had been illegally removed. They don't know how. And that the car was now in a third party's name. And they estimated that their loss was about $20,000. The wife files Chapter 7. And again, the wife just says, look, she just gave it to her husband. She thought he would take care of it. The lender sues in an adversary proceeding under 523A6 for willful and malicious injury. And the court looked at it and said, well, the definition of willful injury is you have to show that you intended a deliberate injury, not just a deliberate act that leads to the injury, and that for malicious injury, and you need to show both of these, for a malicious injury, it has to be a wrongful act done intentionally that necessarily causes the injury without just cause or excuse. So how did the court decide this case?
She wins. Discharge.
Not dischargeable.
Well, that's what.
Everybody's
that's
wrong.
That's the right result, but we,
The wife, the court found that the wife intentionally concealed the car, that she had to know she was depriving the lender of its property. She agreed as part of the contract to return the car if she didn't make the payments. She agreed not to transfer it to anyone without their permission, and that harm was substantially certain at the time she did it. So, not discharged. And that's pretty much all the case law that I have. Hope you enjoyed it. Happy holidays.
I'm going back to my office. Have a great holiday, everyone.
All right, well, thank you very much, Brian, and I guess meeting is adjourned and food is still in the back.